This podcast is brought to you by PLI, the Practicing Law Institute. PLI is committed to keeping you ever current on the dynamic trends shaping the legal world. Learn more at pli.edu/ftpod.
Welcome to Fast Tracked, Emergent Issues in the Legal Profession, brought to you by the Practicing Law Institute. I'm your host, Jen Leonard, founder of Creative Lawyers. Buckle up as we hit the gas and explore the most dynamic trends shaping the legal world. I hope you'll join us as we explore the future of law today. Welcome, everybody, to another episode of Fast Tracked, PLI's podcast, all about emerging trends in the legal industry and what it means for the future. I am your host, Jen Leonard, founder of Creative Lawyers, and I am so delighted today to be joined by one of the most forward-thinking judges I've ever met and have the chance to follow on social media. And we are joined this morning by Judge Scott Schlegel, who is a judge with the Louisiana Fifth Circuit Court of Appeal and previously served as a district court judge for the 24th Judicial District Court, and is a self-described, quote, technology pioneer in state courts, end quote. Welcome to the show, Judge Schlegel.
How are you? Thanks for having me.
I'm so great. I'm so excited to be talking to you, but I have to clarify before we begin and check and be sure that you are actually Judge Scott Schlegel and not an avatar of Judge Schlegel.
I guess you'll have to wait until the end. You'll have to wait until the end, Jen.
All right. I'm gonna just jump in and trust you and assume that I'm talking to the real Judge Schlegel. And I'm making this reference because those of you out there listening to this conversation should absolutely start to follow Judge Schlegel on social media. I follow you on LinkedIn. I don't participate in other social media for my own mental health, but I see all of the cool experiments that you run with all different kinds of technology, but that includes AI avatars increasingly. So if you're not following Judge Schlegel, absolutely follow him. But I want to hear about the origin story of your interest in technology. I hope you'll forgive me if I say that people don't immediately associate courts with cutting edge technology necessarily. But you have really been fascinated with technology long before the Gen AI era started. So what initially sparked your interest in this area?
That's a great question. And, as we talked about right before we got on here, I really am interested in improving the justice system, period, full stop, the end. And so whether that's, utilizing the new LLMs or simply using good old online calendars, it's really not about the tech. In my opinion, the technology is what enables us to create a more efficient, effective justice system. But that's where the impetus is. That's where we begin. And so, I was a former prosecutor before I was a trial court judge. And, just living and breathing the justice system. Anybody who goes to court day in and day out, anybody who has to interact with the justice system gets very frustrated with the, whole, because that's how we've always done it for 30 years. And yes, pen and paper is the best way to use it and throw it into a wire basket. And we all know the answer to that is absolutely not. And so, that's really where it began. When I first took the bench over a decade ago, the first thing I had learned was judges were not allowed to e-sign any orders except for warrants. And that was crazy to me. That was that whole, all right, well, I asked for a hearing or I gave a proposed judgment to the court. Why hasn't it been signed? And the reason was it's because it's sitting in somebody's wire basket and they haven't brought it up to chambers yet. So I had to get legislation passed to authorize judges to e-sign. Then I had to get with my clerk to actually create the e-basket for our signatures. And now, thankfully, every criminal matter, every civil matter, we can e-sign all of our judgments. And that just speeds up the process. And that's just a simple technology that makes the justice system more effective, more efficient, and more accessible. And so that's really where why I like technology. I just think it's the way to go to make us a better justice system.
Well, and I've been privileged to have you join the class that I co-taught with our mutual friend, Bridget McCormick at Penn. And you talked with our students who are very excited about cutting edge technology. And I think you use the analogy of when they make an appointment at their dentist, how much
Yeah.
more tech infused that experience is, right?
Yep.
So tell us a little bit about, everybody's so excited about AI and all the cool things that it does. But I think what you're saying is AI is cool and there will be different applications. And we'll talk about those in a minute, but it doesn't have to be AI. It can be much simpler, right?
Yeah, no, LLMs and AI is just the shiny new object. And I always try and tell everybody, for the love of God, just optimize your calendaring. Let's not go all in on AI and LLMs. It's expensive. It's difficult. There's confidentiality and privacy issues. There's so much going on with AIs and LLMs and Gen AI. So how about we go back to the basics? And, before AI, I used to say I could modernize the justice system in any jurisdiction across the country for under $1,000 a year. Online calendaring embedded in a new court website with a form builder. There are so many applications that I can use with those three softwares that cost under $1,000 a year to modernize the justice system, whether that's, to your point, creating a dental appointment and sending text and email reminders for both civil and criminal, whether that's putting our forms online and guiding you through the process and allowing you to e-file straight there, whether that's delivering courtesy copies just by dragging and dropping your PDFs onto that website. And hey, how about we provide phone numbers and the actual individuals that you're looking for in the courts and their processes and their Zoom links, all right there on a $350 website that I can build for you myself personally.
Yeah, I made a nail appointment this morning and I feel very well supported by my local nail salon. I feel like I have all the information I need. It was very easy to make. And I'm going to go out on a limb and say that my nails are much less important than the civil and criminal justice system. So why does my local nail salon have the ability to make me feel so connected in real time, but we can't seem to make these simple solutions that you've already been using in your courtroom?
You and I can talk about how easy it is, and but it's really not that easy. I mean, there are really a lot of things that go into this. You have to get over the culture of the place wherever you are. You have to understand that judges really do have 100 on their criminal case on Thursday, and then they've got a civil trial on Monday, and they've got to sign warrants over here, and they've got to handle a domestic custody trial over there. And so to have everybody stop, sit back and go, how do I build a website? How do I get an online calendar? How do I embed it? It's actually very difficult. You and I could figure it out if you play with it for about 10 hours, but that's not a scalable model. Most courts don't have technologists, and most technologists don't understand the courts. We can't afford a true technologist. What tech professionals we have in court are heroes, but their jobs are typically keep the servers running. Hey, Judge, here's your laptop with Microsoft Word and Outlook on it. And we call them when we can't figure out how to get on Zoom. So who's going to build the website? Who's going to say what's on that website? Who is going to get a calendar and say, all right, how many reminders do you want? Do you want 1, 2, or 3? Do you want it once a week, once every 24 hours, once every 72 hours? Do you want that to go out SMS and email, or just this or that? What do you want it to say? How much information do you want to go out to? Oh, and there's hundreds of judges. So every judge is going to have his or her own nuance to fix that. And when the calendar breaks, who's going to go in there to actually fix it? And then are we talking about integrating that calendar with the clerk system, or are we talking about layering on top? So it's a very simple thing to do, but very difficult to scale and get it done in any jurisdiction.
So I want to dig in a little bit about the basic tech tools and ask whether you think that the Gen AI moment and everybody's fascination with it could actually lead to the uptake of older technologies, because people, and I count myself in this group, before legal tech or regular tech was not necessarily that exciting to me. But now that I'm excited about a new emerging technology, I'm also sort of thinking about how do I use these other things that are more either historical AI or traditional AI or other solutions. So do you think there's an opportunity for us to have better conversations now because of the focus on AI?
Oh, absolutely. That's why I said it's the shiny new object that's making everybody pay attention to legal tech. And as they're going down this road, it's getting people excited about, I can use technology to, assist me, And so as they're playing over here, you are going to be pulling all of those workflows that need to be fixed before you get there. So how do I load up a pleading into an LLM to do an analysis or a summary for me, the court? Well, are you e-filing it? Are you still scanning your documents? Or are you still pen and papering and putting it in that e-basket or that metal basket? And so in order to get to the LLM, you need to have a more sophisticated system that is actually scanned all of these documents and actually available for you to pull into it. So, that's just one simple example of how you're going to start seeing this kind of move forward. All of the different softwares that we're using, as you know, they're starting to push LLMs and Gen AI within the products. So now that they're being made available directly within the products that we're already using, that's going to move you down the road, whether that's Microsoft using their co-pilots, whether that's Apple using Apple Intelligence, whether that's Westlaw and Lexis and VLEX putting the Gen AI within their products. These are all things that we constantly use. So that gives us a familiarity to actually move to the next level and go, maybe I should start playing with this tool that's already in something that I'm using.
Absolutely. And I hope that we sort of move into a chapter of this era where we're not having to follow all of the different models that are emerging from 4 different companies and what are their capabilities and benchmarking. It's more infused into what we actually use software for.
Right.
And I want to ask about, you have a great blog that you write on your website, and you talk a little bit about the need to balance innovation with tradition, because judges obviously value and uphold tradition in many different ways. And you talked about the need to understand culture before you try to change things. And you use the analogy of baseball as a sport that is also steeped in tradition. And as a baseball fan, I did that's what we love about baseball. And yet it's also a place where they are trying to integrate more AI assisted technology into umpiring. So how do you see baseball and umpires in baseball and judges and their connection with AI similarly? And how can we use that as a lens to understand how judges can use AI?
Yeah, let's throw in tennis because we want to, we don't want to exclude our tennis friends. They're also trying to start, Wimbledon next year is going to get rid of their line judges. Instead, they're going to have AI to determine whether it's in or out. And, I use this as an analogy to kind of talk you through it. And it's a thought exercise to help you through, should we or shouldn't we replace human judgment? I'm not talking about the lawyers. If you're a lawyer, you should be using Gen AI if you know how to use it properly. Full stop. It's going to help you as an aid as long as you're not replacing yourself. And it's much more nuanced than that, but absolutely. Judges' utilization of it, I'm not so sure, especially today. And why do I say that? In baseball, use the analogy, there's something about being able to turn and yell at that umpire that he got the strike zone completely wrong. It's also important to say, and that batters differently. So what are you doing about your strike zone? Are you making sure in the proper place in order to call the balls and strikes? And so when we're looking at judges considering making decisions about people's lives, I don't want anybody to ever say, if Judge Schlegel had used Grok over ChatGPT, I would have had my kids today. Because we deal with very serious things. And even if you out there say, look, AI is going to get it better, I can train a model where it's not so biased as you are, yada, yada. I think it is important for people to say, Judge Schlegel is the worst judge that ever existed, and I'm going to take him up because justice has a feel. Just like the umpire needs to you need to kick a little dirt on the umpire when they make a bad call. There's something about the feel of the justice system. It's a human-centered system of justice. And I'm not okay with turning over to the bot overlords and say, hey, you make the call. Whose singularity are we creating? And at the end of the day, in 10 years, you're going to have judges that have given over human judgment or judgment to the bot overlords, and they won't even know the distinction anymore because nobody knows what the black box is teaching itself over the next 10 years. So look, I'm all for using Gen AI. I think I could use it properly to draft opinions. I don't do it because I don't think, even though I know that I could do it properly without turning it over to the bot overlords, I think the public's not ready for it yet. I mean, I don't think you're ready for me to say I used it in drafting this opinion. It's way too nuanced for people. In a year or 2 or 3 years, when they know how Gen AI works and everybody's using it, maybe yes. But today, I'm not a fan of judges using it to draft an opinion because voice matters. Choice of words matters. And we should be directing where that argument or where that final opinion goes, not have a bot put it out and go, all right, well, the bot's leading me. No, I'm going to lead the bot. And that's my fear for those who don't know how to use it.
So are there ways that you think judges should be experimenting with AI now if it's outside of the opinion drafting context?
Oh, absolutely. Well, first of all, they should be experimenting. They should be using it. They should even be drafting opinions that they don't use after the fact. Go ahead and draft your opinion and then go and take the exact same exercise and do it, because eventually I think you will be using it. And eventually there will be a way for you to use it. But you have all these different judgments that are, that you draft all the time that are just, perfunctory orders. They're not, reasons for judgment. They're just the judgment of, hey, this MSJ was granted in favor of these parties, making sure the decretal language is correct. All of that's fair game. You can use it for calendaring, as we just talked about, smart docket management. You can be using it for SRL and helping with the access to justice issues. So there are many, many ways. I kind of break it down into 3 buckets. Bucket 1, lawyers. Bucket 2, in court usage, like out there in the courtroom. And then bucket 3, in chamber usage. And so if you think through those, where can I layer them? There's plenty of in the courthouse, in the courtroom ways that we can use it. And there's even obviously ways in chambers, legal research. Absolutely. Hey, look, I don't have a problem with you using Gen AI to revise and or make your paragraph more concise. Go for it. Then we're not allowing the bot to tell us I've put in the effort, I've put in the work. Hey, I know this paragraph can be better. Give me some suggestions to make this tighter. There's plenty of things that you can be doing to use Gen AI in chambers and in the courtroom.
So I want to come back to clerks at the end of our conversation, because I saw a great post that you had about predictions that you created with Gen AI. But I'd love to hear first a little bit about some of the experiments that you've been running. And again, people can find them all over social media. But you've really run experiments with AI generated avatars and videos and talked about the implications and applications in court settings. I've seen you do multilingual introductions to your courtroom, which seems like a really great application. And then I've seen you offer some examples that are much more troubling, I think. So could you tell us about some of your examples and what your takeaways have been?
Sure. Let's start with the whole access to justice, as you brought up. There are plenty of times, let's just take jury selection and subpoenas and notices that go out. When we send a notice out and a subpoena out to potential jurors, you get that notice and you start, if you're normal, God, I can't go do this. Where am I going? What am I going to do? There's not even a link to a website. And if you get to the website, you still can't figure out where to go and how to get there. So why do we not send out with a little QR code on that subpoena where you bring it up and Jen, just like this, pops up? It's Jen's avatar. Hey, thank you so much for, coming to the courthouse. Before you get here, I want to make sure you understand what's going on. Don't be afraid. Don't worry about it. We're all good here. Hey, when you get here, there are 3 different parking places. You should park over here for $5, but we're going to validate your parking. Don't worry. It's a little cold. You might want to bring a shawl or a jacket if you get kind of cold. Hey, look, here we do 1 day, 1 week trials. You'll be okay. We'll talk to your employers. And it's nothing more than an avatar video scripted out ahead of the game that can be modified over and over and over again to help people get through the system. So whether that's a potential juror or somebody who is interested in getting a protective order because they're afraid of their partner, we're not talking about legal advice. We're talking about walking you through the system so that you understand next steps and showing them how to get to legal advice if they need legal advice and where the resources are available to them. If you've ever sat in a jury room, they're 30-year-old videos, judges that you're like, God, I can't. You remember when that guy was a judge? And they're so old and they're so bad. And we'd probably spend 50 grand building that video. I could spend $300 and spin up as many videos as I want, different races, different sexes, different ethnicities, different languages, all within 20 minutes. And I just use ChatGPT or Claude or Grok, pick your favorite LLM, to say, here's the old script, make it better for me, make it so that a third grader can understand it, and then spend a few minutes fixing that script, dump it into my AI avatar, and come up with 20 different avatars with 20 different languages, whatever the primary languages in your jurisdiction, and put them on your website. You remember that $350 website we built? We're just going to take a page that we build saying jury and dump those videos on there. Easy breezy, takes you no more than a day to get all that done.
And that sounds great, both as a member of the public who's had jury service and also somebody who thinks we could do a much better job at helping people navigate the process. And it sounds to me, to put a fine point on it and connect with your earlier cautionary tone around opinion drafting, where are the places where there are no high stakes involved and only upside to providing more information more easily versus where are the situations where human judgment is really core to what we're doing? Does that capture sort of the way you think about it?
No, absolutely. There's so much low-hanging fruit that you can do to make, again, the system of justice more accessible and make it more inviting and, help people understand the process. There's so many ways that you can do that for low money, like you said, low stakes. This isn't going to hurt anybody. And then it teaches you how to use these products so that when you want to get to the next risk level, then you go, all right, I'm comfortable now. Let's see what this does. Whoa, I went a little bit too far on that one. One time when I was in the trial court, I built a bot before, as we were first getting started. It wasn't ragged properly. It was going off the rails constantly. Mm-hmm. And I was the one seeing the interaction between the public and me. And I got really uncomfortable really quick and said, nope, I'm not doing it. I should not be the one building a bot. I'm not comfortable that this thing has been ragged properly. I'm out. This isn't good. Maybe somebody else should be doing this. And somebody needs to actually spend the time to rag it properly. So that was too high stakes for me and too many ethical quandaries as well, where I thought it was inappropriate and I stopped doing it within like 2 days after building it.
And point of clarification for the judges listening, what is RAG?
Retrieval augmented generation. Essentially, we can't prevent hallucination. I don't know anybody who has been able to prevent hallucination, but it essentially says this is your knowledge base that you can go and grab from. And so it kind of trying to keeps it on the rails so that it's only going back to the knowledge that you provided it. Again, there's no way to prevent it from completely hallucinating, but it can actually do a better job reducing it. And now I hear there's agentic AI that we can use to even better get rid of RAG and just use agentic AI. But that's a whole nother level that we're not talking about today.
No, we'll ease people into it. We'll have you back and talk about agentic AI. So QR code on your jury summons, helpful videos in any language, useful information, low stakes, good use. What are some of the scarier things you've experimented with and have concerns about in the judicial context?
Deepfakes from an evidentiary standpoint that we're all going to see. As a former domestic violence prosecutor, we handle protective orders all the time. My wife and I have been together for 30 years. She knows everything about me. I know everything about her. She could easily go and she has my voice. She has my voicemail everywhere. She could easily go and clone my voice for next to nothing. Go use ChatGPT or Grok or any one of these things to build up a threatening script dump it into the cloned voice, and have me threatening her on her voicemail. And you can easily spoof a phone number from where it came from. Walk into any court and play that for the judge, and you will get a protective order. You will get the guns, the kids, the animals, and the house within minutes. Oh, and people say, well, you can actually go into court because that's only a temporary restraining order, and go in for the preliminary or permanent injunction and have your hearing. Well, that's great. So here's how this works. They're going to walk into court and say, offer, file, and introduce into evidence. P1, I'd like to play this recording. Ma'am, is this your husband's voice? Yes, that's him. How long have you known him? For 30 years, no doubt. What's his number? This is the number. Judge, I'd like to offer, file, and introduce into evidence. P1. Whoa, that's not me. Admitted. That goes to the admissibility and reliability. That doesn't go to the authenticity. We've already authenticated. She can authenticate your voice. Done. Who are the experts? Who's coming in here to say yes or no? Who knows to subpoena the records of the cell company to show that it's not being spoofed? Oh, and by the way, most of this is SRLs with nobody has any money or familiarity with the system. So we went and we got a protective order now. And then 2 years later, maybe you'll figure it out. That scares the heck out of me. Audio really scares me. Video, you could still tell. I mean, the weird hand motions all the time, or the constant, you'll always know. They're going to get better and better and better. As Sam Altman says, it kind of sucks today, which is scary. And then the audio scares me, and actually photographs scares me as well. Think of a civil, your typical rear end collision or car accident. If you had a bad actor get out of the car and take tons of pictures, they're going to walk into their lawyer's office and say, I took all these pictures. They're going to file suit based upon the testimony or based upon that interview with the client and photographs. Well, how did they get the photographs? They took them on their phone with a Samsung or an Apple. Then they started deleting key objects or key images from those photographs. They didn't bring the cell phone. They waited 6 months and went to Walgreens and printed the photographs. And you have no idea that these objects were here or weren't here. And you have lawyers walking into court, unbeknownst to them, that it's deepfakes. All of that worries me from an authentication perspective. And I think that we need to do something about evidentiary rules. And I've proposed a few. I'm not a fan of changing rules to change rules, but evidentiary rules related to deepfakes, those are ones that I think we need to modify and revise accordingly.
How would you craft some of the changes to try to stave off some of these concerns?
So there's a couple of ways that we can do that. Paul Grimm and Maura Grossman have proposed modifications to 901 to the Federal Rules Committee. They've been looking at it for a year or two, talking about what to do ahead of the game. If you have evidence, good evidence goes one way. If you have suspected evidence, goes another way. I think that lawyers can't bury their head in the sand. There's something in most CCP's Code of Civil Procedure that says a lawyer may not knowingly offer false evidence. And I think it should be a knew or should have known, kind of little heightened. I'm not saying go hire an expert for every piece of evidence that you get, but if your client walks in with all these photographs, you should at least have to ask a few questions so that you can get your spidey senses up or down. When did you take these photographs? Where's the digital source? Why didn't you give this to me before the hearing? Where did you get these from? And really do a better job. And from the flip side, anybody can yell deepfake now and poison the jury. And so I don't think lawyers should be able to run into court and yell deepfake, because we all are looking for deepfakes now. We already don't trust digital evidence. And so I don't think a lawyer should be able to run in and say deepfake unless they have a reasonable suspicion that the digital evidence or the evidence being presented is a deepfake. And if that's the case, handle it pre-trial. Don't come into this courtroom yelling deepfake in front of the jury as if it's not going to change the outcome. It absolutely will. So I think that lawyers need to, they are also officers of the court, and they need to help us with the gatekeeping, because it is really difficult today in this digital evidence deepfake world.
Well, speaking of difficult, everything that you're talking about is making me think how difficult it is to keep everybody up to speed with all of this changing technology. And I'm sure you have this experience. I was presenting to a group of lawyers recently, and based on their questions, it finally occurred to me that this group was still using the free version of ChatGPT. So we're talking about two totally different worlds.
Right.
So how do you are light years ahead of where I would imagine most judges are with respect to understanding the tech and all of the implications? How do we educate the entire profession, lawyers, judges, law students, as all of this continues to change constantly and you just have to constantly refresh your knowledge base? It just feels like such a huge challenge. I'm not sure where to start.
I mean, look, that's why I post on LinkedIn. That's why I built the website. That's why I write these articles. That's why I do these interviews. That's why I travel the country doing this stuff, because the justice system is far too important for us to not try and educate everybody about what's going on with it, and hopefully people watch this video and then they scale me. That's really what it's about is, show everybody the 4-minute mile as possible. And hopefully they go, oh, if you can do it, I can do it too. And if you think of something that's scary, bring it up. Let's all think about it. Some of the things that I say you might disagree with, and that's completely fine, but at least you're thinking about it. I've run into judges that say we should be using this to draft opinions today. I disagree. That doesn't mean I'm right and you're wrong or vice versa. It's just we need to think about it. We need to understand what we're thinking about and then make intelligent decisions. That's what we do as lawyers. We think about it, we analyze it, and then we make choices. But at least you made a choice as opposed to throwing your hands up going, I'm never touching it because it's just too scary, or I'm all in with not understanding the risks and consequences of being all in. And so I think it's important, and I take it as part of my job, actually. It's part of why I became a judge. I wanted to build a better justice system. I quit my job, took out a major medical, cashed out a 401k, and ran for judge while my wife was in school and my son was in school with no political support and no political name. And thankfully, I won. And I did that because I'm obsessed with the justice system. And I think tech can help us build a better justice system.
So let me ask about a public statement you made about a judge using, I believe it was, I'm misremembering whether it was ChatGPT or Claude, but I guess ChatGPT.
Doesn't matter.
Thank you. It doesn't matter. So Judge Newsom from the 11th Circuit created a lot of buzz because he chose, I believe, in a dissenting opinion, so no sort of impact on the holding of the case, to test generative AI on developing a definition for the word trampoline. I believe it was an insurance, and shared very candidly and transparently that he was running this experiment and he was very impressed with the results and he found it really instructive. And law.com asked several judges across the country for their opinions, and some really celebrated it. And I was curious for your reaction because I know you're so tech forward. And I think I was surprised by your reaction a little bit. And I'm just going to read you a quote from your comments that you said, my commitment to the rules and integrity of the judicial process outweighs the allure of this type of experimentation in real cases at this point in our AI journey. We're bound by rules of evidence and judicial conduct that dictate what sources we can consult before reaching a decision. And you make this distinction between traditional dictionaries, which you, in your opinion, are fine to use, and unconventional sources like Wikipedia, Google, and now large language models. Could you talk a little bit more about your reaction to Judge Newsom's use in this dissent?
I presume everybody is familiar with the opinion. So, I won't go through the whole thing, but essentially it was, what's the ordinary meaning of landscaping? A landscaper had buried a trampoline and they were trying to figure out what's landscaping. Judge Newsom was going back and forth in a circular argument of landscaping is landscaping is landscaping. Dictionaries are not helpful. So he went to his law clerk and said, hey, could you use this ChatGPT thing to give me an answer of what landscaping, how it's the ordinary meaning of landscaping. And so they went through this exercise. And as you pointed out, he wrote a 30-page concurrence kind of walking through the process. And my point was, to quote Austin Powers, how about no? Dr. Evil, how about no? I just think that's a foot too far. We, as you just noted, we're bound by certain rules of evidence, especially appellate court judges. We are bound by the record, what comes into it. And we can't go outside of that record. Even as a trial court judge, you don't go pulling up a Google map to figure out what did that accident look like unless they offer that into evidence. And so when you go to an LLM, it's not like going to a dictionary. People make this argument, well, a dictionary is essentially crowdsourcing for the ordinary meaning of words. So what's the difference between that and an LLM? Crowdsourcing what ordinary meanings for a landscaping. Well, first of all, the rules allow us to look at a dictionary and Black's Law that all permitted. The rules allow us to go on to Westlaw and see, have there been another debate or discussion over landscaping? And why do the rules allow that? Because arguably you can traverse it. You can allow the lawyers that come in and say, I agree or disagree. There's nuance to that case. That case is not on all fours, and distinguish why that's not on all fours. But if I'm going to an LLM, I'm literally hiring every expert in the country since the beginning of time to talk about landscaping and the ordinary meaning of landscaping. And did they have buried trampolines back in the 80s or the 70s when the LLMs have been training off of all this data? I can't call an expert on any issue and pick up the phone and go, hey, Jen, I've got this really crazy insurance thing going on. Can you help me through this? I can't do that. And some rules allow judges to actually call experts, but then you have to tell the lawyers, and then you have to give the lawyers an opportunity to traverse that witness. How do you traverse a black box? How do you do it? And we all know it's not repeatable either. I took the exact same definitions or question and dumped it into my ChatGPT and came up with a different answer. To your point, was he using free or not? Did he change the temperatures of that LLM? Did he tell it how to act? Did he give it pre-instructions like I have? You are this, you are to act like this, you are to speak like this when building it. Don't know the answers to that. So I think it's a foot too far for that use case.
So in both the quote in that situation and our earlier conversation, you leave the door open, it seems to me, for a future application of generative AI in these different contexts that get much closer to decision making and judgment. Right. Is there a threshold that the technology needs to meet that you've thought about when that might be? Or is it, like you said earlier, when society is more accustomed to generative AI?
Well, I think it's both. I think when the legislature grapples with this, they might go change the rules of evidence and say, and you may use a pre-approved LLM that's been pre-approved by the state Supreme Court because it's been ragged properly, or whatever the new term of the day is. I don't want to close the door because the technology advances every single day. So everything I tell you today, Jen, might be wrong tomorrow. And, our feel of the justice system today is certainly going to be different tomorrow. And so while I'm forward facing and tech forward, I'm also a traditionalist. I'm also love the rule of law. And, it used to be, I love the rule of law, not the rule of men. Now we're talking about the rule of bots, so I don't want to add that third piece to this ever. If you want to do that, go mediate with the bot overlord. All good, completely consensual. You all have decided to go that route. But if you get to a point where you need to file a suit in court, I think human judgment is the only way to go. And that doesn't mean don't use Gen AI to assist with that human judgment. But most people can't use these products today without replacing human judgment, in my estimation. And I think that'll change down the road as we get more familiar with the tools and learn how to build the tools.
Well, I think this is why you're such a compelling voice in the conversation, because you're both tech forward and also very protective of the tradition and the rule of law. So I know judges listening to this will really be compelled to think more deeply about these issues. And you mentioned forward thinking, and I'd love to close our conversation. I could have asked you 700 other questions popping up in my mind. We'll have to have a whole series with Judge Schlegel. But you had a post recently where you worked with AI to develop predictions for 2025 in the land of AI. And the AI, I believe, came up with 3. And I want to ask you what your thoughts are on each of them. So I'll go through them one at a time. The first prediction was that we would have AI law clerks. Thoughts?
Oh, 100%. Absolutely. Especially in firm land. Firms, they already have them. They're already using them. I've built a law clerk, because to your point, voice matters, and so when I would feed it, the briefs of opposing counsel, and again, know how to direct it. I don't say, give me the answer. I would say, here's the case law that's relevant. Here are the facts that are relevant. Here is the answer. Here's the structure that I want you to draft it. Now, draft me a first draft. It was good. The answer was correct, but it did not feel like me. It was not my voice, and I wouldn't have been so flowery. I wouldn't have been so, so much dicta in it. I write in a very direct manner. I think you want the answer. I'm going to give you the answer. It's going to be concise, and I'm not going to talk about other implications that are not before me. The bot did all that. And so I had to then take it and give all of my previous writings and previous opinions and say, in my voice, write the same thing. And it was great. It took me a few minutes. Again, I didn't use it formally, but that is how you could properly use an LLM, assuming the public's ready for it.
Mm-hmm. Mm-hmm. And I'm making an assumption, but I'm going to see if I'm right about this. I'm assuming you're not envisioning in the next couple of years the replacement of law clerks with AI, but the complement of law clerks with AI. Is that accurate?
And I give this speech all the time. I would never trade my law clerks for an LLM. I would forego ever using an LLM to have my law clerks. But I'm fortunate that I have law clerks. There are plenty of judges around this country that their jurisdictions cannot afford a law clerk and do not give them a law clerk. And so in those scenarios, this is a great fill while they're fighting for a budget to get them to work in tandem with. But if I'm sitting there and I just had 100 criminal cases, I just had a full busy motion day, and I've got a civil case in MSJ tomorrow, I go do the MSJ, and I give you my ruling, and then a lawyer goes, Judge, I like some reasons for judgment. That judge has got a custody trial the next day. They don't have time for that. So that judge could go in the back, take the recording from that proceeding, dump it into an LLM and say, prepare reasons for judgment for me, clean it up, get it to the lawyers out that week. That is how I see Gen AI being useful and helpful to judges today.
Okay. Prediction 2, amendments to the rules of evidence to address admissibility of AI generated evidence. We just talked about this in some more depth. Do you think that this conversation will get going in 2025?
Already working on proposed legislation for the state of Louisiana, and hopefully we'll have something filed in March.
All right. So that's a great answer. And number 3, I want you to describe actually what these are, because we didn't have a chance to get into this, but the prediction from the AI is that modular court systems will go from vision to reality. You've written extensively about your vision for modular courts. What are modular courts, and why is 2025 the year?
So as we know, this is very expensive to get done. And I always try and tell everybody, most jurisdictions, most states around the country, let's say you get an infusion of a couple of $1 million and say, all right, you got all this money, go fix the court system. You're never going to come close. And so what I try and help people understand is that you should have a roadmap with Lego blocks. Let's say you want to build the castle, and you have the castle cost $20 million. Well, the moat costs $2 million. The carriages and the horses cost $3 million. The whatever the catapult or the whatever you're throwing out there for protections costs $5 million. And what happens is everybody says, I need a new horse. Instead of saying, build the carriage, hook the old horse up to it, and start heading towards the kingdom. And trade for a new horse when you're halfway there. Because if you keep buying the new horse, i.e. upgrading your computers with the $2 million, you're never working your way towards the kingdom. And so we need to start contemplating and considering the state Supreme Courts. This is the Lego set that you need for the moat. This is the Lego set you need for the horse. this is the Lego set you need for the carriage. And when I get 2 million, here's $500,000 to start building the moat, so that when we get each one built, they come together and you have a new castle and we're good to go. But otherwise, you're just stuck in this circular updating the new horse.
Okay. And you feel 2025 is the year that we start making headway toward modular courts?
God, I hope so.
Okay, Judge Schlegel, before we leave, I have to learn about some things you've been posting lately about VR headsets in court proceedings. And I just am going to frame it like that and let you take it from there. And I'm sure I'll have follow-ups, but I loved your piece about all of the things about balancing innovation with fundamental fairness and how it relates to VR headsets. So tell us more.
So if you've been following the news, a judge in Florida was the first in the States, apparently, to allow VR goggles on a stand your ground case. First use of it, period, at the end, but it was used in a stand your ground case. So apparently a guy was charged with an aggravated assault, firearm, and he allegedly pulled it out because he was getting accosted, if you will, people getting really close in his face, and he got scared and pulled out a firearm to get them away from him. That's kind of the setup. I'm sure I have a few of the facts wrong, but that's kind of the general setup. The defense created or recreated the scenario in virtual reality and put it on the judge's head so that he could actually see from the defendant's perspective what went down. I always knew that VR evidence was coming, but I always assumed it would happen in a civil case where you're talking about, damages. Here's how my client was injured in this car accident, or here's how my client was injured in this, men-mal case. I always figured it'd come in that, but now it's coming to criminal. And so it starts getting you to think about, well, a lot of the studies that were cited in this news article talked about how VR is like story living, and where you are personally experiencing everything in the virtual reality. Well, that kind of flips the trier of fact reason for the trier of facts on its head, doesn't it? In this case, it's the judge. Think about a jury trial. Don't we want object people looking from the outside in? We don't want them experiencing that fear or proposed fear of the party, in this case, the defendant. Do we want the judge experiencing that fear? Well, we don't know that, there is a subjective piece to this and there's an objective piece to this, depending upon what you're trying to prove. And so do we allow such a thing? That's something that we need to think through and think of it from the flip side. So let's assume that you're a defendant on trial for murder and the prosecutors create crime scene and the actual murder. Do you want the jury to sit there and feel the actual murder? Do you think that they're not going to find whoever's on that other end guilty because they've now felt an actual murder? And then they talk about VR and how do you actually create this scene? Are we equipped as courts to say, well, that 1 inch should have been 5 inches in virtual reality. And if I've got goggles on and I'm living it, that 1 inch to 5 inch, whether it's intentional or unintentional, could change the way the trier of fact felt. So there's going to be this crazy potential for manipulation, whether it's intentional or not is irrelevant. How are we going to be equipped to say that science is wrong? We're not technologists, or that, crime scene that you created. This is far afield of, PowerPoints that I used to build as a prosecutor, putting little things on the, the crimes diagrams versus actually putting you in the crime. So I don't know about this.
I was so interesting because it seems, to your point about the evolution of demonstrative evidence, the technology is getting good enough that the video recreation of a scene will become much more realistic, right? But it's only, it sounds like to me, the immersive nature of using a VR headset that evokes the emotion that concerns you. So it's not even a, Go ahead.
No, I've also talked about when I give this, I say, accident reconstruction of yesterday. And then I say accident reconstruction of tomorrow. And I play like Sora type videos. I don't know that even that's okay. Even if you can get the science right, are you going to, again, to the point of, if the damages are here, is it going to be way up here because you actually have an actual, literally as if they're looking at the accident on a screen. And it's even more so if it's immersive. So again, I don't know how this is going to play out in the courtroom. Clearly, this judge allowed it. That's his discretion to allow it. There's no rules against it. And so that's kind of what every trial court judge is going to have to start thinking through. How far do I allow this to go from an evidentiary standpoint? And it'll be a while before the courts figure it out. But that's why we're talking about it, right?
Yeah. And I don't envy the judges who have to sort of figure out this new landscape. Thank you so much for walking us through that.
Yeah, absolutely.
Judge Schlegel, those of us in the profession are so grateful to you for all of the thought leadership that you provide to us in the midst of your incredibly busy schedule. And I know that the judges out there will want to follow you. Where are the places people can find your content?
JudgeSchlegel.com is where I put all of this stuff. JudgeSchlegel.substack.com if you want to get on the email list, and then on LinkedIn at Judge Schlegel.
Amazing. Thank you so much for your time, Judge Schlegel. And I'm excited to see how the predictions unfold in the year ahead.
It'll be fun. Thank you.
And thanks to everybody out there for joining us for another episode of Fast Tracked. We'll see you next time. And until then, be well. I hope you enjoyed this fascinating conversation as much as I did. Visit pli.edu for more insights, education, and resources for navigating this dynamic landscape. And until next time, stay curious and stay adaptable as we work together to chart a course into an exciting future.